aside from all the things that you've heard about, there has been an attempted federal response to the foreclosure process, and it's the Home Affordable Modification Program, about which there hasn't been really that much talk today, but it's important. It can help some people, and the presenters that we have here today are going to try to describe how that process works and how we can try to help our clients, and when it doesn't work, what we can do about it. So I'm going to pretend that I'm Charlie Manuel, the manager of the sometimes highly successful Philadelphia Phillies. I'm a lifetime Phillies fan. I make no apologies for that. And just introduce my star lineup, the one that won the World Series a few years ago, not the one that didn't make the series last year. So Dan Sullivan from Action Housing in Pittsburgh, Rachel LaBush, staff attorney at Community Legal Services, and Aisha Baruni, also staff attorney at Legal Services. You guys, take it. I'm going to get out of the way, let you play. Yeah.
I'm lead off today. All the pressure's on me to get on base, I guess. Good afternoon. Everybody still awake? Kinda, sorta, because I'm about to knock your socks off with housing counseling. For what it's worth. Let me make sure I can use this correctly, because there's only 4 buttons, right? And I can't. Oh, cool. All right. I apologize. I got like 12 of these at work, and I never know which one I'm going off of, so just bear with me. What we're going to do is we're going to kind of go over the housing counselor role in a very sort of general way, and then how it bleeds into HAMP. Rachel and Aisha will be doing a lot of the details for the legal professionals out there regarding HAMP denials and processes and things of that nature. So let's get started. Housing counselors. The key for a housing counselor is to make sure that you can sit down with a homeowner and really take a look at the general affordability, not just of the home itself, but of the entire finances. While the legal professionals will take a look at whether or not things were recorded correctly or executed correctly, we have to take a look about whether or not there's real, true affordability in the homeowner situation. So we're going to go over not just income levels, but debt loads on the house, the principal, the interest, the escrow, and everything, plus all the other finances, whether or not it's car loans out there, school loans, credit cards, things of that nature. And we have to determine the viability of home ownership. Unfortunately, many people come into my office on a day-to-day basis that just cannot afford their homes anymore. Sometimes it's a predatory or subprime loan that they should have never gotten in the first place. Other times that the income has been shifted so dramatically because of medical issues or divorce or whatnot that they just can't afford that home anymore. My job as a housing counselor is to take a sort of outside-the-box perspective of that. I'm not living in this situation. I'm not in the bubble, so I have a better idea of what actually can be pulled off money-wise. We come up with an action plan, and then that's going to be 6 in one hand, half dozen in the other. Sometimes it is about home retention. In other cases, and I see a lot of these lately, especially in Allegheny County where the unemployment rate has basically doubled, where it's exit strategy. It's selling the house, it's deed in lieu, short sale, something to that effect. And then the key is to provide guidance to the homeowner. HAMP lasts forever. Most people ask me, well, how long is this going to take? And I'm like, well, how long have you got? It's a slow bloodletting, and it's docs are getting lost, and MPV tests and investor criteria and all these things, and homeowners just aren't aware of it, nor do most of them even care. They just want to know, can I save my house? So they need someone who they can call up, whether it's for guidance or cathartic, they just want to blow up and yell at somebody. As a housing counselor, I need to be there for them to pick up that phone. So again, review affordability. I should delete that. It's redundant. I'm going to get to that second point because that leads me to soapbox a little bit because the situation has changed dramatically in the last 10 to 15 years. So we'll get to negotiate with lenders. Recommended exit strategy, like I said, in many cases we run into folks who just can't afford the house anymore. We got to talk to them about, okay, listen, you might have some equity in the property. Financially, this might be the best move you want to go into. Now, I don't recommend pushing a client in any direction. If your homeowner comes in and says, Dan, I'm going to do whatever it takes to save this house, then you owe that to him to do whatever it takes to save that house. I am remiss, however, by not going over all the strategies of, listen, if this doesn't work out, here's what your next step is going to be. Refer client to legal service. I think this is really, really, really important. And I'm not just saying that because a lot of you are lawyers. That tie-in, I think, has been missed in a lot of cases. Sometimes legal services aren't talking to housing counselors or vice versa. We need to be working together. We need to be able to share that information. I know locally in Pittsburgh, we have a very close relationship with neighborhood legal services. Kathy, thank you. It makes my job easier. Hopefully I can make their job easier. Refer to other social services. There's a lot of great organizations out there that can help with clothing, food banks, Angel Food Ministries, things of that nature. As a housing counselor, it's my job. I got to know who these people are, what their contacts are, and get my clients out to them as soon as possible. Oh, wait, sorry. I'll soapbox for a second. Negotiate with lenders. All right, 20 years ago, when I got a house, not me personally, because I'm only 36 and that would make me 16, you went to a brick and mortar, right? Your local bank, you got a loan. They were lending money upon deposits within that bank, okay? So if you fell behind, here's the option for the bank. I can eat this loan, and all of a sudden I'm short on my deposits, or I can work out a deal and keep everybody in the community happy. So it was easy 20 years ago to pick up the phone, you call up the bank, and say, let's make a deal. Okay, this is what kind of income we got. This is what kind of equity there is. Let's work out some sort of payment plan. And most of the banks would say, yeah, we'll do something here, because they were community lenders. 15 years ago, give or take, secondary market blew up. And just so you know from a reference point, and don't hold this against me, but I worked for a very large mortgage bank as a regulatory compliance officer, National City, which is probably why the colors are like this now that I think about it. Subconscious, stupid. So what would happen is I worked in correspondent lending, so that was the boom of the secondary market. So we would buy loans that were closed by Joe's House of Crabs and Mortgages, and there was no money down. I mean, they didn't lend the money out. They had no depositors to answer to. They had no investors to answer to. They closed the loan. They didn't care what the paper looked like, and then they would sell it to someone. And National City, for instance, would buy it, and then we would go and sell the note agreement to Deutsche Bank or Goldman Sachs or somebody like that, okay? So now all of a sudden your borrower falls behind, and you call up the servicer and say, hey, help me out. And the servicer goes, why? I never put any money into this thing. The only thing I'm losing is my service release premium. It costs me like 15 cents a day to service this loan, so I'm not really seeing any loss on the table for this thing. And if I take it to foreclosure, I'm really going to recoup my losses because I get the first cut at the sheriff's sale. That has limited us as housing counselors to actually work out deals. Try not, this is my suggestion solely, okay? I don't try to justify my job as someone who gets modifications. I don't have any weight in that. I can't make a borrower diligent. I can't make a lender answer me. I can send over docs, I can make phone calls and things of that nature, but I have no money in this. I have no say in this game. And I want to make sure that housing counselors remember that our job is to give the best advice humanly possible and not just get loan modifications, because it piles up. Because after a while, you see case after case after case, or you can't get loan mod, you maybe start thinking you're not doing something right. It's not you, it's the system. Okay, negotiate out terms. Mostly modifications, rate, term, and product. It's quite simple, lowering the interest rate, re-amortizing the loan over 30 or 40 plus years, changing adjustable rate mortgages to fixed rate. Forbearance agreements, which are typical under FHA, is what we're seeing right now, which is a set period of time in which they will lower the payment in accordance to whatever the income level is currently with the homeowners. I see a lot of this with like FHA programs where they're homeowners unemployed getting UC benefits. Deed in lieu of foreclosure, which I'm sure everybody here knows about. Short sale, selling the property, of course, for less than what you owe the bank. And then straight foreclosure. And I mean, there is a certain level of counseling for that. I have a lot of homeowners that come in and they're going to face foreclosure. They're calling me at the 11th hour. They don't know what to do. At least I can give them some advisement about, okay, well, here's some apartment listings. How much money do you have saved? I know my company or my organization has funds available to help with relocation and renting moving trucks and stuff like that. And then, of course, reinstatement. Making home affordable. There are no officers from the U.S. Treasury Department here, correct? I'm not pro-HAMP. I'm not anti-HAMP. It's a really good idea gone wrong for me, personally. It's like the last 3 Star Wars films, like, cool, but you could have done better. General criteria here is primary residence. First mortgage has to be under the conventional mortgage loan limit of $729,750. Borrowers have to be facing a financial hardship. So unlike HEMAP or the ELP, you don't have to be down amount of months. You just have to pass some sort of, you're an imminent default risk. Mortgage origination prior to 1/1/09, which up to a few months ago I had not seen any. Now I'm getting a rash of them. That is simply because of either medical issues or the high unemployment rate right now. And the PITI, which is the principal, interest, taxes, and insurance, regardless of whether or not that loan is escrowed, as a housing counselor, I have to do that calculation to figure it out, has to be above 31% gross household income. Here's the rub. That was a really good idea when Sheila Bair and the FDIC kicked it out. Made sense. We will get everyone to 31%. If you're lower than 31%, however, we will just recapitalize the loan and get you straight again because you have an affordable mortgage. Okay? The problem what we're seeing now is that servicers are actually using that justification to deny HAMP loan modification, saying that, well, it's really easy for us to fix this, so we ain't going to do it. Sorry, I'm jaded. Additional eligibility factors. Servicers may not require a borrower to waive legal rights as a condition of HAMP. Servicers may not require a borrower to make a good faith payment or upfront cash contribution. However, if it's an in-house and it's like a HAMP Light or a HAMP Junior or Bride of HAMP or whatever they're calling it, they are allowed to make that sort of upfront fee, good faith penalty. I'm seeing a lot of people getting pushed out of in-house modifications because they don't have 25 or 300 down or whatever. So. Borrowers in active litigation regarding a foreclosure loan are eligible for HAMP. NPV test. I'm not going to go into all the details. These guys, they understand it better than I do. They're going to articulate it better than I will. But the website there will lead you to the link where there's all the discourse and the calculations and everything like if you want to know about the NPV test. Basically what that is on surface, you have the general eligibility criteria. So say I meet all that. Okay, I pass every test. I've turned in my documentation on time. Everything is good. I think I got a loan modification, but lo and behold, now the servicer, who remember doesn't really make the call on this, has to do this test to send it to the back-end investor to say, hey, can we actually get a modification done? With the GSEs, I'm seeing it happen. With private mortgage holders, not so much. The test basically is to determine whether or not at the end of the day, as an investor on my portfolio, is it worthwhile for me to foreclose on this house or not? If I have a portfolio with 100 loans on it and 25% of them are tanking, guess what? It's still probably in my best interest to do the foreclosure, okay? Outside of REMIC tax loopholes, what I'm going to get back from maybe the FDIC, if I bought them from IndyMac, I'm going to get like 3 times the loan amount, fun stuff like that. You're going to see these situations where it is in the best interest of the mortgage servicer and the investor to foreclose on the house. It's not the traditional, if you gave me $100,000, now you're not going to get it, so you're going to lose this money rub anymore. Any questions? Can I do that? Usually we wait, but anybody? Modification Waterfall. So the 31% ratio is where the HAMP program is supposed to get you, okay? There's 3 ways to go about that. One is I'm going to reduce the interest rate. Take your 7.5 to 4.5. Right now, the cap on that, or the floor on that, is 2%. I don't know about you guys. Anecdotally, I have not seen anybody lower the 2. I saw 2.5, and that was a negative amortization adjustable rate mortgage 4 years ago, 3 years ago, 3 years ago. So that was like a worst case scenario loan. They will re-amortize the loan up to 40 years, and then they will do a principal forbearance. That's the 3rd step. So if the rate reduction doesn't get you to the 31%, the re-amortization doesn't get you there, then they'll do a principal forbearance. The key with this, guys, is that it's not a forgiveness. So that difference is going to be due if they refi or if they sell the house or something to that effect. So that money is going to be due again. Now, of course, most of that should be settled at closing if they refinance or sell the house. But please tell your homeowners if they get this, that this, forbearance part doesn't just disappear. It's going to be due at some point. Again, interest rates for is 2. Modified effective rate is for 5 years. What they've been doing is step levels. So they'll put you in for 2 years at one rate, and then year 3, 4, and 5, they'll might be up a little bit, like 1%, to what is then at that point in time the Fannie Mae market rate at the time of the mod, not the time of the readjustment. So if the Fannie market rate has and will change in 5 years, you're getting that old 5-year rate from Fannie, which is 4.25% or something like that right now, give or take. So, and then the forbearance again is effective until sale, payoff, or redefault. Document acknowledgement and review. This is the biggest problem I'm having in terms of getting docs over and sending them over and over and over again. And you know the numbers as well as anybody else, but for some reason Wells can't get them. Within 10 business days following the receipt of the initial package, the servicer must acknowledge in writing the borrower's request for HAMP participation. I don't see a lot of that. Diversion programs have helped. Attorney McKeever's office, some of the other offices that we use, they have been notifying us via email, and that's made it helpful for us, but borrowers are still not getting letters regarding this. Within 30 calendar days from the date of the initial package received, the servicer must review the documentation provided for completeness. All that means is that they have to make sure that all the docs are there. They don't actually have to do the underwrite review on it at that point in time. So they just go through and make sure 4506T, tax returns, bank statements, pay stubs, RMA is filled out. That doesn't mean an answer. It just means, yeah, we got everything. If the package is complete, the servicer must evaluate the borrower's eligibility. There is no set time frame for the decision to be made per MHA handbook. I couldn't find one. If I'm wrong, please let me know. The problem what we have is this. As soon as the docs are in and they're complete, it sits in a queue. Queue's, I don't know, standard underwrite queue was 30 days, so MHA's got to be like 60. Standard underwrite says that if it's 60 days old, they're going to need a refresher of all the docs. So once the underwriter got the docs, guess what, folks? New doc time. And the cycle continues. So I'm seeing this a little bit better now, especially with diversion programs where I'm able to directly send the information through like legal counsel, but we're still seeing major issues with this thing. Once a decision is made, the servicer must send a borrower a trial period plan notice or an approval or a non-approval notice. That's no problem. I'm seeing a ton of those. And I'm actually seeing some trial plans. Of course, the problem is with the trial plan is it's three months plus. I was just telling Dawn a case of a situation, which is actually in the diversion program, which an individual was on a 3-month trial plan for 13 months. Denied loan modification, and then removed from the court-ordered diversion program because there's nothing else that could be done. So
if I can just jump in real quick, if you have, we do see the non-approval notices, but if you have a homeowner who, what we see a lot is homeowners don't hear about their HAMP application. They call their servicer and they're told, oh, you're denied. It's in the computer, you're denied. They have to get a written denial notice. They must get a written denial notice. And if they don't, it's a basis for escalation that we'll be getting into. So just wanted to jump on that.
And as a counselor, because I have all the information, I know what the income should say. If that denial looks fishy in any way, say they're using bad income, which I get a lot, resubmit. I mean, the glory of this is that these guys are so big and they're not keeping their hens in the roost, if you will, is that you can apply and apply, apply. Now, I don't like dragging things out forever. If it's a lost cause, it's a lost cause. We have to move on to the next case. What average caseload for a housing counselor has got to be, 70, 80 cases probably, give or take, maybe. It could be higher. So I mean, we gotta feed people through the system at some point. But if the income is wrong, that, guys. Let's get those docs back out and have them reevaluate. If the documentation is incomplete, the servicer must send an incomplete information notice that lists the additional documentation needed. I've seen a better job of that within the last 6 months, give or take. We are getting that. Incomplete information notice must be given to borrowers at least 30 calendar days to provide the missing documentation. It's in the letter. I mean, I'm losing 2 weeks by the time they get the letter in the first place. So, I mean, if you don't get it, then we make the referrals back to legal assistance. There's information in the handbooks regarding hotlines to call for MHA and things of that nature. Please inundate them with calls. They do listen, but you have to be a very loud voice to get anyone at U.S. Treasury Department to listen. But if we're all working together and we're all making the phone calls and we're all squawking, they will listen, I think. Incentives. 1, the homeowner gets to keep their house. Community's better. County taxes get paid. But for the banks, $1,000 at modification, $1,000 up to 3 years for performing mods. That's $1,000 a year. $500 for one-time mods on current loans. Investors and lenders get a $1,500 one time if the mod meets the DTI criteria. That's both the front and the back end. I think there's a back end ratio, which is going to be your mortgage amount, car loans, credit cards, school loans of 55%. You do not get removed from making home affordable if you're over that 55%, but they will request that you do some sort of ongoing credit counseling and housing counseling. And then, of course, the homeowner will get a $1,000 principal reduction annually for the loan performance up to $5,000 for 5 years. All of this contact information in the websites is in the handouts and the booklets that you guys got. So you don't have to like scurry and write this all down or memorize it or whatever. Again, the general Making Home Affordable site, which is where I go to get RMA, the 4506T forms, everything that you need. Frank Dodd disclosure, I think, should be on there too. Hotlines for Fannie and Freddie. And then HAMP information, including access to the handbook, is that bottom site. I found that to be fairly effective. I can pull up servicing agreements, every single servicer who signed on to HAMP, I can pull those up. I can pull the handbook, all, was it 84 pages or something now? I would have made everybody copies, but, and that's just my stuff. So, questions? I went through it fast, I apologize. But I don't want Sam standing up and kind of like telling me I gotta hurry. Anybody? I mean, there's gotta be something, right? No? Crickets. All right, thank you.
My name is Aisha Baruni. I'm a staff attorney with Community Legal Services in Philadelphia. I'm be addressing 2 issues regarding HAMP. The first issue will be HAMP escalation, and then the foreclosure stops in HAMP. I don't have a PowerPoint for the escalation issues, but if you want to follow along in the materials, it's page 130. And I'm going to go through things kind of quickly. We have a lot of HAMP material and about a half an hour. So, okay, so who here has assisted a homeowner with a HAMP application, HAMP denial, anything like that? All right, and who's had problems? Everyone who's done it, right? Okay. Now, when HAMP first rolled out, it was difficult to tell who you should talk to when you had problems. Things have gotten better. They're not perfect by any stretch of the imagination, but really what I want to do here is encourage everybody who's working with homeowners on non-GSE HAMP applications, denials, any HAMP issues for non-GSE loans to escalate the problems that you run into early and often. Treasury is very sensitive about how poorly escalation was performing before. They're trying to do a better job, but when they don't get calls from legal services attorneys and housing counselors, they think they're doing a good job. And we've tried to explain to them in conference calls, the reason people don't call you is because you didn't do anything before, so why people waste their time calling you? They want to see calls, they want to see emails, they are getting better. They have over 100 people working in the HAMP Solution Center now, whereas before I think there were fewer than 15 when HAMP first rolled out. So they've really made a commitment staffing-wise, so let's try to utilize that and show them how the servicers are not complying with the program. The materials I'm going to go through really deal with the non-GSE loans. If you are working with a borrower on a GSE loan, first you need to look up to see whether it's a GSE loan or a non-GSE loan, and I've included the resources for you to look up those loans, and I'm just going to talk about the non-GSE loans. The escalation contact
for HAMP problems for trusted advocates, or I think is what the language Treasury uses, for housing counselors and attorneys who are working with borrowers, is the HAMP Solution Center. And we've got the phone number, fax, and the email address right there in the materials. When you're working with a borrower who's having a problem with HAMP, you should try to go up first the ladder of authority within the servicer itself. That can be hard to do. It can be hard to get past the first level. If you get to a supervisor, sometimes they just, parrot back what the first representative on the phone told you, and sometimes it can be hard for folks to get a good contact at the servicer shop who has authority to help you out. I want to encourage you to work the ladder at the servicers, but also not to wear yourself out doing that. If you can't do it, go ahead and escalate the issue to the HAMP Solution Center. There are a lot of situations where escalation may be beneficial, and it's important to escalate the matter as soon as you think there's a problem, not to wait until the sheriff's sale is scheduled for next week or the plaintiff is able to take default judgment the next week. It's really important to try to get that process done early because it shows that your borrower has been working with the servicer, has been trying to get things done, that the servicer is not complying, and it can be your contacts with escalation are something that you can bring into the courtroom. If you're in a jurisdiction that has a mediation program, you can tell the mediator that you have been working with the servicer, but that you've also escalated the matter. And this is what escalation has told you. Whether they'll listen to that, I can't guarantee, but it's definitely something that you can bring in. So just want to go through kind of quickly the situations where escalation may be beneficial. If you think the borrower was not reviewed for HAMP, and they should have been, if you believe that the borrower was improperly denied HAMP, the denial letter that the borrower got is deficient, the basis that's stated isn't a basis that's allowed under the program. If a borrower received a trial modification, complied with the trial modification, and didn't receive a permanent modification, and I would say here, to go back to what Dan was discussing, is if you have a borrower who was in a trial modification, who made their payments, and more than 30 days have gone by and they haven't heard about a permanent modification, I would say escalate that issue now. Add the pressure from escalation onto the servicer to review those papers. The quickest turnaround I've ever had between a trial mod and a permanent modification is when I got escalation involved, and they were putting a lot of pressure on the servicer to flip that over into a permanent modification quickly instead of just letting it linger in a queue.
I would just say that sometimes there's a strategy decision to be involved in whether you want to push them along quickly or not. Because
I guess whether if you
if you think the person should qualify, that's a great idea. If you think that they need some sort of change in circumstances before they can qualify, and you want to drag out that foreclosure stay while the application's pending, then maybe you want to let it sit.
So when I'm advocating for escalation, I'm sort of advocating that you want the HAMP Solution Center to put pressure on the servicer to act. And that, is a strategy decision you have to make depending on your borrower. Sometimes borrowers are given trial modifications that they can barely make for those months, and they wouldn't be able to make that permanent mod. So you may not want to push that issue, or a variety of other reasons. Other instances in which escalation may be beneficial is if a servicer filed a foreclosure court case without properly reviewing a borrower for HAMP, and that's an issue I'll touch on when I talk about foreclosure stops. If a borrower has applied for HAMP but doesn't receive a decision, or doesn't receive that decision in writing, if the servicer takes an action in violation of the foreclosure stops, if the servicer charges upfront fees for the modification, the servicer tells the borrower to go ahead and miss a payment. If the servicer refuses to stop a scheduled foreclosure sale while the borrower is being reviewed for HAMP, or if you get close to that sale, you don't have to wait for the sale to go by to say this is a problem. If the servicer claims that they're waiting for information or guidance from Treasury, they say Treasury is causing the delay. If you see any of that finger pointing, escalate the issue. And if the servicer advises the borrower to intentionally misrepresent their personal or financial information. In order to escalate, you can do it by telephone. You can also do it by email. I usually do it by email because you have to send in writing the information anyway. So if I escalate by email, then I have a paper trail of the day that I contacted the HAMP Solution Center. I've had the unfortunate experience of escalating a matter by phone and having it get lost by the HAMP Solution Center. So at the very least, usually if I escalate a matter, I do the initial escalation by email, or if I do it by phone, I follow up with a confirmation email the same day to sort of document what I'm doing for my borrower. You need to provide certain initial information to escalate a case, and the information requirements are not very detailed or numerous. If you escalate by phone, you'll get a bounce back email after you get off the phone telling you to provide certain information by writing, and that information is what's listed here. Just sort of the general information, the homeowner's name, the property address. I'm not going to read through it all because you have it there. One of the things that's really important is to make note, whether you're doing it by email or by phone, if there are scheduled deadlines. If you have a mediation conference coming up, if you have a sale date coming up or that's gone by, any kind of court deadline or other deadline that's being imposed on your borrower. That could even include a deadline, a date by which the mortgage company would be able to take a default judgment, something that's going to happen that's going to change the game for your client. Notify HAMP Solution Center that that's going to happen. And I've seen them work on those cases faster than other cases. Even though this short list, the name, the property address, your name, all of that is all that's required, it's important to give as much information about the problem as you can, and to do it as, I guess, clearly as you can. It can be hard when a case is really muddled to sort of put forth a time frame about how non-responsive the servicer has been, but it's important to try and put that out there because the representatives are reviewing many different cases, and they stay with the case. They're supposed to stay with the case until it's resolved, so it's helpful to make it as clear as possible. Include dates in your inquiry. And also, if you're sending things by email, you can attach documents to that email by PDF. So if your borrower got a bad non-approval notice, attach that notice. You don't have to spend a lot of time summarizing the notice and talking about why it's bad. Attach the notice. If your borrower says they made their trial plan payments and the servicer told them, we haven't gotten those payments, attach the receipts for that. Just attach everything you have to cut back on some of that back and forth, because a lot of the complaints that borrowers and their advocates have had about the escalation process is that they say, I called escalation. I told them the problem. They said they would look into it. They called the servicer, they heard the servicer's story, and they just parroted that story right back to me. It's a problem. And it's still a problem, I'll be honest with you. But if you attach some of the documentation supporting your side of what happened, supporting your contention that somehow the handbook or the supplemental directives were violated, or that your borrower is being given the runaround, attaching some of that there sort of cuts off the ability for the servicer just to parrot their story to the representative when upfront you're presenting some of that evidence that supports your story. Okay, so we're still talking about the initial information that's required to escalate a case. So the initial information, those additional details, and then one final thing, and this is critical, is you need an authorization. Not just an authorization for you as the borrower's advocate to talk to HAMP Solution Center, but also an authorization for you as the advocate to talk to the servicer. And if you can produce both of those at your first contact with the HAMP Solution Center, that's best. But if you can't do it right away, you want them to start investigating as soon as you can get those authorizations in after, because the HAMP Solution Center won't give you any information until they have those authorizations on file. So just a couple more things before I move on. Tips for escalating a case: escalate it as soon as you suspect there's a problem. If it's been 9 months since your borrower finished their trial plan and you really want to get them into a permanent modification, escalate now. Don't keep waiting. Get that ball rolling early, because escalation can be slow. Sometimes it can be fast, but it can be slow. And a lot of times escalation is slow because the servicers are slow. So start things early, and I recommend following up with the HAMP Solution Center often. Follow up once a week. Send an email, or you can do a call. I prefer email because then I have documentation that I've been trying to reach out and figure out what's happening. The escalation timeframes are supposed to be more regulated now, since Supplemental Directive 1015 was issued, and that's now been rolled into Handbook version 3.0 is out. Now, for some of you may not know, The HAMP guidance is now found in a handbook rather than in all of those messy supplemental directives, which is really helpful. The problem is they keep issuing new handbooks, and they issued a new one last week, an hour after we put our presentation materials in. So some of the citations may be a little bit out of date, but Handbook 3.0 is the most recent version. It's on the hmpadmin.com website. So bookmark that page. Anytime you have a HAMP question, refer to that page first. And then just one final issue. I'll get into this more when I talk about foreclosure stops, but effective in February of 2011, if you escalate a case and that escalation is still pending, a servicer is not permitted to sell that house at a foreclosure sale. They may be able to kind of move along with the case, but they're not allowed to sell that house. So this is why I say it's helpful to escalate the case early and to keep pushing it. If the HAMP Solution Center resolves the case, the servicer can go ahead with the sale. And communication between everyone can be bad. The HAMP Solution Center may not tell the borrower everything that they've told the servicer to do. The servicer may not tell the lawyer for the plaintiff bringing the court case everything it's been directed to do. So the borrower's advocate, to the extent possible, has to keep everyone in the loop. The borrower's advocate needs to keep following up with the HAMP Solution Center to find out the status of the escalation. When the HAMP Solution Center representative tells you what they have advised the mortgage servicer to do, the borrower's advocate should then tell the mortgage foreclosure lawyer, to the extent that there is one that represents the mortgage company bringing the foreclosure court case, should tell them what they were told by the escalation center. We found that the HAMP Solution Center will talk to somebody at the servicer, but the servicer never tells their lawyer what was said. And the lawyer sometimes will sell the house not knowing what the servicer has been told. That shouldn't happen. If it happens, it should be undone, but we don't want to undo sales. We want to stop sales from going forward when they're not allowed to happen. So I'm going to move on to the foreclosure stops because we are running really short on time. Does anyone have any quick questions? The material's here, and then we have a contact number also, so hopefully they're helpful. But really, I think if there's one takeaway from the last 7 minutes is please try escalating your cases. Please follow up with HAMP Solution Center and be aggressive with them and trying to get them to pay attention to the way the servicers are not complying with the HAMP guidance. You have the PowerPoint for this. I'm not actually going to go through it. The HAMP guidance has certain what are called foreclosure stops, and what it means is that in certain cases, a servicer is not allowed to proceed with a foreclosure case or file a foreclosure case if a person hasn't been reviewed for HAMP. And I'm looking at, this PowerPoint starts on page 132 of the materials. The first stop is that a servicer may not file a foreclosure case against a borrower or hold a foreclosure sale if a borrower has not been reviewed for HAMP. If a borrower comes into your office because they have a court action filed against them and they were not reviewed for HAMP, or they applied for HAMP and they didn't get a decision, it's arguably a violation of this. And they're not supposed to be filing a court case without reviewing the homeowner or going to sale if they haven't reviewed the homeowner. So you would want to escalate that issue and also bring it to the attention of foreclosing counsel. The second stop is that a servicer must suspend a previously filed foreclosure action if a borrower is in a trial period plan. This means that if your borrower applied for HAMP after the foreclosure was filed, so let's say the foreclosure is filed, you're in a jurisdiction that has a mediation program, you apply for HAMP, your borrower gets a trial plan. The plaintiff in that foreclosure case cannot take default judgment against your client. They have to put a pause on that case because your borrower is in a trial period plan. They can't take a judgment, they can't move ahead to schedule a sale, they can't hold a sale. And the third stop I just mentioned when I was discussing the escalation issue, and it's effective in February of 2011, is that a servicer may not sell a house at foreclosure sale while an escalated case with HAMP Solution Center is pending. I'm not going to go through the rest here because there's a lot, and Rachel has a lot to talk to you about HAMP litigation. But one thing that I just want to bring to your attention is that if a servicer violates a stop, I'm taking you now to page 141. Escalate the case, contact HAMP Solution Center about that. You want to ask the HAMP Solution Center to tell the servicer to undo whatever it did that violated the stop. And you also want to ask the HAMP Solution Center to tell the servicer that they have to disallow any of the fees associated with that action. So if the foreclosing entity filed a complaint against your client in violation of the foreclosure stop because your client was not reviewed for HAMP, there are costs and fees associated with doing that. There are court costs, attorney's fees, and other things. They're not allowed to be assessed to your borrower. And the Department of Treasury has told us that HAMP Solution Center has the authority to tell servicers, you may not charge those fees to this borrower. So hold them to that. Your borrower should not pay any of the costs and fees associated with the servicer violating a foreclosure stop. Okay. Does anyone have any quick questions?
I'm just surprised with that number one. I mean, that it's like before they file a complaint, the servicer needs to review that.
Yes.
But complaints are filed every day. This looks like a robo-thing.
They,
Are they really reviewing that?
Well,
there's certain steps to solicit the borrower to apply for HAMP, that they're supposed to take a certain number of letters, a certain number of phone calls, that sort of thing. I mean, I don't know if they really are doing that in every case. The servicers would probably say, well, we tried to reach out to the borrower and they didn't apply.
They were told to do an in-house scrub on loans in default, basically, and then send out letters. I mean, the question is you go back to your client and say, hey, within the last 6 months, have you received a letter from Wells Fargo? They're going to be like, yeah, like 100, and I don't know what to do with them. So tracking that becomes difficult because the lender and servicer come back and say, yeah, listen, we sent something out. It's in writing. We gave them 30 days to respond to us. So I agree. I don't think they are looking at everything, but it's hard to kind of put that down, you know,
I think
memorialize it.
If the borrower expresses interest in HAMP in any way, I think even verbally, that's supposed to initiate the process where they're supposed to
Yeah.
try and get a complete application from the homeowner. So I don't think they're doing that.
We see
So-
all the time where folks in the Philadelphia program, they get a complaint filed against them. But they said, I tried calling, I tried negotiating, I contacted them, but I still got a complaint.
It's a perfect segue into my part of the presentation.
but that's a good case to escalate. The housing counselor should escalate because a servicer is supposed to make certain efforts to contact a borrower to solicit them to apply for HAMP. And if a borrower tells their housing counselor, listen, I don't remember being asked to apply for HAMP, the housing counselor escalates that issue, the servicer has to have documentation of their efforts in their file. And the HAMP Solution Center, when they contact the servicer, will ask the servicer, what did you do to solicit this borrower in accordance with Section 3.1 of Handbook version 3.0? And they're supposed to pony up those papers. So escalation is the process to try and get to the bottom of it. It's supposed to be the fact-finding process. It's not perfect, but it is the process. Yes?
But also, isn't it true that every homeowner is not entitled to HAMP? I mean, if it's not Fannie Mae or Freddie Mac, and the service is not a voluntary participant in the HAMP program, they're not entitled to that HAMP.
Right. It's only, the foreclosure stops only apply to borrowers who have the ability to file for HAMP. So who meet the basic eligibility requirements that Dan went through. The property has to, certain requirements about the property and certain requirements about the borrower. Only participating servicers are required to participate in HAMP. So the foreclosure stop doesn't apply to non-participating servicers.
It is, though, the vast majority of loans are now covered by HAMP, I think over 90%. So most of the servicers, loans you see will be with servicers who are participating in HAMP.
Rachel, before you get started, let me just remind everyone to come to the microphone to state your question, or if they don't, presenters, please restate the question. And let me just say here that a number of advocates tried to get our state Supreme Court to enact a rule that would have required foreclosing entities to state whether they were subject to HAMP or not, and then to tell the court what the status of the case was. That was that was not successful. What we were successful in doing was something we'll talk about later, and that's getting the court to recommend that counties do diversion programs.
Right. So the foreclosure stop that Aisha discussed and that's in the materials is something that can be very useful in defending a foreclosure action on the litigation side. And I have a lot of materials in here. We won't be able to cover them all today, but I just want to make sure you know what resources we have. And if you do have any questions later, or you want more examples of things, or more cases or whatever, I'm Rachel LaBush. My email address is all over these materials. Feel free to contact me. There have been, I did a search recently just to make sure there were no decisions in Pennsylvania that I wasn't aware of, but so far there haven't been any decisions reported on Westlaw involving HAMP in Pennsylvania in a state or federal court, which is sort of freeing in that we're raising these issues in a lot of ways, and some pretty successfully, I would say, as are people around the country, using HAMP as a defense to a foreclosure action, using the fact that a servicer never properly reviewed a person for HAMP or botched the application review process in some way to defend against a foreclosure, to open a foreclosure judgment or even undo a sheriff's sale of a property that should never have happened because the HAMP review process was not properly done. Just want to mention 2 issues. I included a whole bunch of one-pagers in the materials. Starting at page 146, there are 2 that I did, and there's several that the National Consumer Law Center did. Because I'm sure that those of you who work with HAMP know the same kind of scenarios come up over and over again, and there are ways of dealing with them. They're in those one-pagers. 2 that I thought were especially interesting were the ones that I was interested in writing about were just issues around delayed modification, which I'm sure you all have seen. One issue that's come up, and I have a lot more on that page, but page 146, one issue that comes up over and over again is when the person's in the trial period and they don't get a permanent modification, the trial period extends for months and months, do they have to make payments, the trial payments, for, you said 17 months, you had a client, for 17 months? The answer in the guidance is clear that that person cannot be turned down for a permanent modification because they didn't make payments after the trial period passed. And I have the citation in there on page 146. When the modification becomes permanent, whenever that may be, even if it's a year delayed, it's supposed to put the borrower in the same position as if the modification was made in a timely manner. So it can't be held against them that they didn't make those payments. And then I just wanted to call your attention that the Dodd-Frank Act updated the process for disputing denials based on NPV values. That was in Supplemental Directive 1015, and it's in the new handbook, version 3.0, which, as Aisha mentioned, came out right after we submitted these materials. But I think that the summary that I put at page 148 kind of covers that. When people get denial notices starting next month or the end of January, they should include all those NPV values that formerly you had to ask for, and now you have 30 days to dispute them, and it has to be in writing. You have to dispute them all at once. And you do have an opportunity to dispute the property value, which wasn't really available before, which is a really crucial issue in a lot of cases. And if you think the servicer is really off on the property value, which could cause your client to fail the NPV test, you just need to provide them with some sort of basis for why the property value, in our cases, usually we're saying it's lower. That would help our clients. The property value is lower than they think it is. Some basis for that. And you don't have to go out and get your own appraisal. You just need to show them, well, the place next door went for whatever, just something written or a Zillow or whatever. And then you can give the servicer $200. This could be a problem in our cases, but they're supposed to go out and get an appraisal if it would make a difference in the NPV test. As far as litigation, I didn't include a ton of cases in the materials because the NCLC website is fairly good at keeping up with unreported decisions and posting them on the website. I included a list of the decisions that they have on the website, which includes many of the ones that I've summarized in the materials. But HAMP has been raised basically several different ways recently. In our cases, we're raising it as a defense, and I included a sample answer raising HAMP defense and also a sample motion to set aside a sheriff's sale with the supporting memo. And you can see there how we allege these things. We haven't been getting written opinions on it, but we have, correct me if I'm wrong, Beth, but we've been, has anyone had a summary judgment decision on the issue yet that you know? I'm not sure. We're throwing it out there. It's not failing. And we are able to cite to cases in other jurisdictions, the ones that I summarize in the materials and also Beth does. Basically, to be really broadly general about it, many courts have been reluctant to recognize HAMP claims in an affirmative case where somebody's suing the servicer for botching HAMP, but have mostly been willing to see HAMP as a defense to a foreclosure based on a number of different theories. And there's an article in here that from a few months ago that kind of summarizes the HAMP litigation that's out there, and I think one of the conclusions they drew is that courts aren't terribly picky about how you couch your HAMP defense, but what you need to do is educate the courts about HAMP and that the servicers for non-GSE loans are voluntary participants in HAMP. They sign the servicer participation agreements, which are all available online. Those agreements require the servicers to follow the guidance. The guidance requires the servicers to review people for HAMP before filing a foreclosure, to offer them HAMP if they're eligible and not go through with the foreclosure. And if you allege that, and if you allege facts showing the person has not been reviewed yet or is eligible for HAMP, that the courts have been willing to impose a stay on the foreclosure in some cases, throw out the case. And it also can be raised in the context, as I'll mention at the next session, of any kind of court mediation process, the diversion programs. The judges and mediators are or quickly will become educated on the issue of HAMP and very familiar with how our clients get the runaround and have to submit documents over and over, and how their applications aren't processed properly. I guess the main theories that are out there for enforcing HAMP through litigation are breach of contract. People try to argue a third-party beneficiary, forth an argument that even though the servicer participation agreement is between the servicer and the Treasury Department, that it was meant to benefit homeowners, so homeowners should be able to enforce the agreement against the servicer. This argument has mostly not been successful, even though it sounds intuitive. What the contract theory that has been more successful recently, if you have a case with good facts, is breach of contract based on the client getting a trial plan that says if you make these 3 payments, you will get a permanent modification. The servicer's not, because that is a contract, arguing that is a contract between the homeowner and the servicer, arguing that that should be enforced. And then promissory estoppel theories that the servicer said, apply to us, we will evaluate you under this program. We promised you, we promised the government we're going to do it under these certain criteria, and especially in cases where they advise the person to stop making payments or other terrible advice like that, and the homeowner relies on it, makes their 3 payments, makes their 17 payments, expecting a modification. Using promissory estoppel as a defense has been somewhat successful. And I also cite cases where courts just get truly upset and are willing to find negligence on the part of the servicer for not handling the modification process correctly, bad faith in how they've been negotiating with the homeowner, and using that to allow the homeowner to defend against the foreclosure and even impose penalties on the servicer and even servicer's counsel in those cases. So if you are interested in using this as a defense, I'd encourage you to look at these opinions in the materials here and on the NCLC website, and to put them in your pleadings. I'm sorry that we are out of time. Just want to make sure I didn't miss anything that's here that you should know. There also are a few class actions pending. I just wanted to mention there were a whole bunch around the country that were filed against Bank of America, particularly based on this breach of contract theory. They've been, I don't know what's the word, centralized? Consolidated, thank you. Consolidated into multi-district litigation in the District of Massachusetts, and that includes 2 Pennsylvania class actions as of now against Bank of America based on that breach of contract theory with the trial plan. But recently, one of those cases just survived a motion to dismiss? I think it's recently survived a motion to dismiss. The court found that that the plaintiffs had made out a case for breach of contract, and so those cases are going to move forward for now. Does anyone have any questions on this whirlwind? Mm-hmm.
It has to do with page 150.
Mm-hmm.
And I've had several services, Wells and Bank of America, that when you ask them who the investor is, one, they won't provide it. Two, they'll say like the investor will not do a HAMP, will not do a loan modification. And you say, why? So they keep telling you they just won't do it. So according to this sheet here on 150, you're stating that we can actually escalate this to Kent if they won't provide that information?
Yes, and we've spoke recently with the Treasury people about this, and they said that they are for having these. The HAMP Solutions Center people are going to be referring those issues specifically to people within the Treasury Department who are equipped to actually examine the pooling and servicing agreements and see if there is an investor restriction in there. So they're going to be looking into these much more closely, and they won't just take some sort of bald denial for an answer. They're going to require that the actual language in that agreement that they're saying is a restriction. They're going to review that and see whether it really is a restriction.
So if you
I
had
had this
trouble,
one client from Wells that they've given her at least 6 trial modifications. And the bottom line is this, that they will not, they're saying that the investor will not do any type of loan modification, period. And then when you say who the investor is, well, I can't tell you. Well, can you escalate this? Well, no, we can't escalate it. So it's like this lady has been on a trial mod. I think I've had it for almost a year, and I can't get anywhere with this client because they won't do anything.
I think you got 2 things. One is that they're not allowed to give you a trial mod unless they've actually run through the investor criteria and done the MVP test prior to the offer, which is an error that we saw a lot of.
Okay.
The second one is that U.S. Treasury made it completely okay for an investor to come back and say, I'm not participating. And I mean, I'm using that with parentheses because it's not about them participating. But they were allowed to come back and say, listen, we are not going to allow any HAMP modifications under this security. So the Treasury gave them that right. I think what we're seeing from Treasury now is sort of a retraction of that to a certain degree, to take a look at it a little more deeper and say, was this just carte blanche that you threw into security, or do you actually have a reason under the master servicing contract to do that?
Right, because when you actually look at the language in most master servicing agreements, they do allow the servicer to make modifications, and most of them have this boilerplate language that is the same essentially as HAMP, that allows the servicer to make modifications if they're likely to get a better return from the modification than from proceeding to sheriff's sale, which is essentially the same as the NPV test. So it's a minority of the agreements that actually have a restriction like the one they're claiming to have in your case. Yeah. I would say definitely escalate that case, see if they can make something of it. Okay. And also, if that case is in any kind of litigation, I mean, it would be, I would think, a good candidate for referral to an attorney, because if they're offering your client agreements that they don't have any intention, trial plans, and they don't have any intention of ever offering her a real agreement, that seems like it would hit a whole bunch of the defenses to foreclosure using HAMP, such as promissory estoppel and bad faith and all those things.
so, and if you have that problem, when you escalate that problem, the investor is not participating problem, the servicer is supposed to provide the supporting documents, not to you, unfortunately, although we ask for that, but to Treasury to evaluate. But they don't have to give them to Treasury, really, unless you make a stink about it and show that there's a problem. So if you escalate those issues and bring it to the HAMP Solution Center's attention, they can get those documents from the servicer and make a decision about whether the servicer is not being truthful about the restrictions in the documents.
The investors themselves are coming back and saying the servicers are full of crap and they don't know what they're talking about. I mean, there's lawsuits right now coming out from investors back to servicers saying, you guys weren't working in our best interest according to the master servicing contract by denying these. The servicers got lazy.
And just one last point I wanted to make on litigation. The government is defined what kind of modification fits under HAMP and what doesn't, what will allow them to get the incentives that Dan mentioned and what won't. It may be that your client in the end doesn't actually qualify for a HAMP modification at the time when they're finally evaluated, but based on the behavior of the servicer in handling them. Maybe they would have qualified at an earlier time, or maybe the servicer misled them for long enough that you can still argue and ask the servicer to say, fine, if it's not a real HAMP mod, you still need to give them a modification that's essentially the same as they would have gotten under HAMP. And we've seen that with some different servicers, or very close with some different servicers.
Question. This just raised a question in my mind, and I think you might have alluded to it in your presentation. Is there a clear financial disincentive for the servicers to be modifying these loans, and they're using the investors as an excuse, and they're making more not modifying these loans?
Can I take that?
Yeah, you probably.
Yeah.
And if that's the case,
Right.
then what can be done on a macro level to, create that tension?
We could change IRS code, which is really easy, I hear. No, the problem that you're going to run into here from a servicer's perspective, especially in secondary market, is I have no money in the game. Again, I never lent against the loan.
Right.
So I'm only collecting the servicing premium. At the point of time of sheriff's sale, if the property is either sold or it stays and it sells on the open market, guess who gets first cut? Servicer. It's the investor who takes the hit. The only thing on a macro level to change this is to help work with the AG's office, the Department of Banking, to say, listen, the investor's argument saying that the servicer is not working in the best interest of the portfolio and the servicer, or the security, and push that back, because that's not only going to positively affect your homeowner by getting deals done, but it's also now the servicers are breaking a contract with the investor, and we can nab them on that too.
But
would be the hope.
if there, for instance, are large investors like pension funds or
Yeah.
city governments or things like that that are getting hosed through this servicing investor agreement,
Right.
can we use them to make the servicers do loan modifications more judiciously?
I haven't seen an effective strategy in which a housing counseling organization or even a group of housing counselors were able to get together and do that. I do think, though, that some of the stuff that David Blaken earlier was talking about and the AG's office was talking about is something that we need to remember, which is our communication levels with both the AG's office and the DOB. Those guys might have some push to do something, and that's where I would escalate that, as I would be on the phone with those guys constantly saying, this makes sense in every single situation. It passes all the smell tests. Why isn't a deal getting done? And I think if we dig, we're going to find out it's just the servicer saying, I'm going to make my hay when this thing goes to sale. I hope that answers.
And to some extent, the law firms as well.
You know what? I mean, not to play devil's advocate for plaintiff counsel here, and I don't owe Mike any money, but they're gonna. My understanding is they get paid regardless. They're gonna get paid if it goes to foreclosure. They're gonna get paid if it gets modified. They're gonna get paid if it gets reinstated. And at the point in time with a lot of these cases that we're looking at, I've run up most of those legal charges. I mean, we're knocking at the door for sheriff's sale, and most anecdotally for most of what I'm dealing with. So I don't think. I could be wrong here, but I don't think they get the full benefit of taking it all the way to foreclosure and have the sheriff's sale. Am I wrong?
But one incentive I could see is that the same firms do handle ejectment actions for them, which is a whole nother lawsuit.
Another suit.
For.
Okay.
Yeah.
So then, yes. I was hoping not everybody was out for it for the money.
It's been a great panel. Thank you very much.